So as I said previously, these protected rights began, this liberty of contract began to be popular in the late 1800s, really the 1890s. But we see the court in 1905 read that liberty of contract into the Constitution as a fundamental right. So we're going to cover Lochner first as the rise of capitalism. So this is where substantive, or the rise of substantive due process. This is where the court institutes this idea of substantive due process and begins reading these protections into the Constitution that weren't explicit textually there, and over time proved to be exceedingly unpopular. So the facts in this case, New York passed a law that limited bakers to 60 hours per week and 10-hour days at maximum. The law was designed to protect workers from industrial conditions, which threatened health and safety, which is a classic police state legislative power. States themselves, individual states, are absolutely empowered to protect the health and safety of its population, as all of us living in lockdown at this time know. And this was another example. This maximum work hour law and maximum hours per day law was an example of the state regulating in that health and safety environment. Well, the owner of a bakery in this case required his bakers to work more than those hours allotted in New York, which was ultimately a constitutional violation. So the question in this case was, does New York State's law limiting does New York State's law limiting number of hours worked and number of hours of day work violate some inherent right to contract or some inherent liberty? The Supreme Court holds that the law in question in this case is unconstitutional, and that the law interfered with the individual baker's right to enter into any contract he wished. And therefore, this freedom of contract is now juxtaposed as a liberty due process interest to the state's interest of regulating health and safety of its population. So the Supreme Court does play a balancing act. The opinion articulates this idea that we need to balance individual level interests versus state level police powers. And in this balance, the court argues that liberty is always going to win out against states' ability to police for health and safety, that liberty is always going to win. States certainly can enact these laws, but the statute has nothing to do with health and safety. So the state can regulate health and safety, but in this particularized case, this maximum hour law had nothing to do with health and safety, according to the court, and thus infringed upon the liberty of employers and employees to engage in economic contracts. So essentially, the court says that this is an absolute fundamental right on them, and that states cannot limit this right even when they're exercising their police powers over health and safety, which is expected to be where they are the strongest, because the Constitution very clearly gives the states the ability to regulate in that area. Now, this decision was a 5-4 decision. It was heavily criticized, not only now, but also at its time. Justice Holmes dissents in this case pretty vehemently. He says this case is decided upon an economic theory, laissez-faireism, which a large part of the country does not entertain. But the Constitution is not intended to embody a particular economic theory, whether of paternalism or of laissez-faire. It is made for the people of fundamentally different views. And so the criticism that Justice Holmes articulated was that this idea of laissez-faire capitalism is not one that is represented within the Constitution. In fact, no theory of capitalism or no theory of economics is represented within the Constitution. That within the Constitution, it's made to make a government, not an economic system. And therefore, by reading a particular theory of economics into the Constitution, seems to be untenable. And so Lochner was very much criticized. This decision was exceedingly criticized. Um, and it became much easier to criticize Lochner and substantive due process as the country started going through um, a significant depression. And during this depression, during this time period, FDR gets elected, and FDR begins pushing a lot of New Deal legislation, a lot of legislation which, at its very nature, regulated the environment between employer and employee. And the Supreme Court of the time actively struck down these New Deal regulations um, on the basis of this idea of liberty of contract and more generally substantive due process. And they did it consistently, time and time and time and time again. Well, in 1936, FDR gave one of his infamous fireside chats. And in that fireside chat, he talked to the American people and told them of a plan he had in which he was actually going to pack the United States Supreme Court with jurists that would support his interpretation of the Constitution and allow this New Deal legislation to be passed. It was a plan that wasn't very popular among the American public because the American public likes courts to be independent. And the American public largely didn't support this threat. But the Supreme Court absolutely heard what FDR was saying, absolutely heard the threat to their legitimacy, this external threat to their legitimacy. Because if you pack the court, you make the court just another political body. And the court itself, realizing that the only currency it has to get its rulings actually enforced, the only currency that it can spend is its legitimacy. And so this external threat to their legitimacy, which threatened to take away their power, was deemed a significant threat. And so in 1937, the court switched. Chief Justice Hughes and Justice Roberts stopped siding with what were then known as the Four Horsemen of the Apocalypse, four very conservative judges who were actively striking down this legislation. They switched and began in allowing these laws to go through and thus invalidating this idea of substantive due process and this liberty of contract more generally. Well, the court switches and this New Deal legislation begins to get passed, and largely interpreted within the legal community, we see that as the failure and the end of, or at least the fall of, substantive due process. And that is very explicitly explained in the next case.